We have some updates on the never-ending lawsuit, seemingly, that Alyssa Mercante, former ex-Kotaku journalist, is still suing me for. What? I'm not really sure. I think it's defamation and saying things about her. I honestly, genuinely don't know after reading through the entire 48 or 56 plus pages of nonsense. But we have an update from it. The last time we talked about the situation, we cover this message to the court from Alyssa's lawyer that were frustrated that we didn't meet the time deadline. And because of that, they followed up with this letter asking the court to sanction me and ask for me to pay the lawyer fees or whatever the judge decided. And when this happened, many of the Smash JT haters were doing victory laps, making YouTube videos and talking about how, oh my God, Smash is so cooked. He's so done. He's been fooling everyone because this is the reality. Alyssa's totally owning him. And look at his lawyer was late with information. When in reality, and this is why I tried to explain to people even before all this happened, is we were trying our best to provide information to her lawyers. They were asking for many things that were beyond the capability of being able to give to them. They didn't exist. Many of the things they were requesting are not things that you can get, like stats that don't exist, available. There's nothing there. They wanted specific analytics, deciphering like users in New York for specific things. And I'm just like, you can't break it down like that. You can get certain areas, you can get New York for certain things, and we sent them all those things that we could get for them, because right now they're trying really hard to get jurisdiction, and Alyssa is in New York and I'm in California, and because the internet is not, it's been proven multiple times in courts that it is not qualifying as jurisdiction for a lawsuit in a different state, they need now to provide information to the court to prove that I have specifically set up business in New York, and because of that, they want to sue me for that. And they know full well that that isn't a thing. I have never set up business in New York. I don't have a business in New York. I don't know a damn thing about New York. That's not anything about what I do or what I am. And their backs were so up against the wall with the situation that they offered to drop the defamation case. I think they have like 5 counts they were trying to sue me for, with stochastic terrorism and other things. I'm not even sure that aren't even laws, right? And they offered to drop what I would argue was what I thought she was suing me for, was the biggest one, the defamation, if we were just willing to concede jurisdiction, basically saying to the judge, hey, we've come to an agreement, judge. We've dropped one of the counts that we've put against them, and they are allowing us to have this heard here in New York. So now we can move forward. We don't need to prove jurisdiction anymore because they have agreed to have the case heard here. And we're like, no, we're not going to agree to that, because first off, this entire lawsuit is complete bullshit. Like, it really is. At the end of the day, I don't think she even knows what she's suing me for. The allegations that she's levying at me are not things that she can prove, because I would argue deep down, she knows none of it is true. I would argue she's just really mad and really doesn't like me, which is fair. You're allowed to not like people in this world. You're allowed to hate people in this world. It's fine. The problem is you can't just sue someone because you don't like them. You can't just sue someone because you hate them. You have to have like something they did tangibly in the court of law that is a actual law that you can prove that's like they crossed this boundary that is a law that they're not allowed to do. And I never did anything like that. So she's trying to prove that we have jurisdiction first, which is they don't, just to be able to have this court case heard there, which even if jurisdiction does get accepted, which would be insane if it does, then they have to go to prove the allegations against me, which would be a field day in itself. Like, you talk about kangaroo courts, my goodness, that would be something for the ages. Anyways, to catch you all up at speed, this is where we left it off, with them begging the court to sanction us, right? And my lawyer, Ron Coleman, sent this response to the court. I'm not going to read the whole thing, But this is a banger letter. This is to the magistrate. Dear Judge Escanazi, I am counsel for defendant and write in response to plaintiff letter motion for sanctions at ECF number 56, all this other stuff. I begin with this because it was the subject of the court's specific inquiry and because I owe the court a candid explanation. This is from my lawyer. The short answer, because we were quote unquote late by a few hours or a day or 2 days, I don't know, like literally we were trying our best. We're providing all the information. We had a lot of communication with them back and forth on what they're asking for. We're trying to get it to them as best as we can with everything we're providing to them. It was never enough. So they're always asking for more, which I would argue is part of their strategy to make it look like we weren't providing things. The short answer is that I made an error in judgment. I believed incorrectly that the joint status letter filed at ECF number 55 effectively communicated to the court that additional time was needed and that the matter would be addressed at the next conference. The joint letter explicitly stated that defendant is contemporaneously making a motion to extend time to comply with the court's orders and the corresponding end date for jurisdictional discovery. I take responsibility for the fact that the separate motion contemplated in that language was not filed. Plaintiff's motion makes much of my email statement that I was, quote, not worried about the deadline. In context, those emails reflect my mistaken belief that the status letter approach would suffice, not any contempt for the court's authority. Indeed, at 2:09 p.m. on February 17th, before the deadline expired, I emailed opposing counsel to confirm the scope of the supplemental production and to schedule a virtual meet and confer the court had directed. The production effort was ongoing and communicated to plaintiff's counsel throughout. Plaintiff's February 17th email confirmed that plaintiff understood supplemental production was forthcoming no later than Thursday, February 19th. Defendant proceeded in reliance on that shared understanding of the timeline. At 5:53 p.m. on February 17th, I acknowledged the technical difficulties that had arisen and reaffirmed the commitment to Thursday's production. That is not the conduct of a party proceeding in bad faith. It is the conduct of counsel who believed the parties were proceeding cooperatively and that a short supplemental period was understood. In layman's terms, what Ron's saying is, hey, Your Honor, we had a conversation with these people. They understood that it was going to take a little bit longer. And from our understanding that they were okay with that because we were on board with why it was taking longer and there wasn't an issue. And then almost you could argue behind our back, as we were confirming with them that we're all cool with it taking a little bit longer because we're trying to make sure we get everything correct for them, they go behind our back and go straight tattling to the judge. Hey, judge, they're late on this by a day, and now you need to sanction them, which is what they pretty much did. And that is typically not looked highly upon in the court when you start doing stuff like that. It's a bad look. I'm not going to, like I said, I'm not going to read through this whole thing, but Ron goes on about how the sanctions are disproportionate, talks about how we're trying our best. A lot of the things they're asking for, we can't produce. It doesn't even exist. And it's impossible to give these things when we can't do that. So I also had an update, which I can't go into details on it yet because I haven't confirmed with Ron, but I can say that Ron has shared an email with me from a very big company. And this very big company's legal team has responded to us and to Alyssa's lawyers, telling Alyssa's lawyers that the things that they're requesting, even they don't have. So how are we supposed to be able to provide it if this really large company doesn't have it that they're trying to get? It's almost like they were going to them to get the information to then bring to the court to prove that we are ignoring what they're asking for. And I'm like, no, we're not. We're literally giving you everything you're asking for. I would argue above and beyond in this discovery or limited discovery area, whatever it's called, that we're bringing to the table. We're going way above and beyond to make sure that you don't have that excuse of saying we're not providing you the information. So after Ron sent this to the court, we waited a couple days, and then we got an update on February 26th. This is from the court itself, and it's not great for Alyssa Order denying 56 motion for sanctions. In evaluating whether to impose Rule 37 sanctions, the court must consider a number of factors, including 1, the willfulness of the non-complaint party or the reason for non-compliance. Basically saying we weren't ignoring, we were trying our best, but they were being ridiculous with how they were asking for things. 2, the efficacy of lesser sanctions. And 3, the duration of the period of noncompliance. And 4, whether the non-compliant party had been warned of the consequences of noncompliance. Here, both parties acknowledge that the discovery production was ongoing and only several days late. Indeed, plaintiff filed the motion for sanctions on February 19th, just 2 days after February 17th deadline for production. In light of the brief duration of delay and the reasons cited by counsel for defendant for the delay, the court concludes sanctions are not warranted. Order on motions for sanctions. Basically, the judge or the court or whoever, I'm assuming this is from the judge, but coming from the court system, saying that right here, this is a bad look. When they say this here, I read this as the judge is looking at this like, you sound like you're just tattling on them to try to get them in trouble when they're working their asses off trying to get all this information to you. Like you couldn't give them an extra day, especially when you guys are in full-on communication and an understanding behind the scenes of what's happening. It's not like we were ignoring you. It's not like we weren't providing information. We were fully on working with you the entire time, regardless of what you try to put on the internet or what your people are trying to say about us. We are working and being fully compliant behind the scenes on everything we can do. And this is the court being like, we have all the information here. You're trying really hard to get this guy in trouble when you could argue they're being ridiculous about what they're arguing for. So this was determined by the court to not give sanctions. And the sanctions could have been up to and including and beyond me paying for Alyssa's lawyers for this extra time that it's taking us. And God only knows what they would have tried to charge us for that. So again, this goes to they're trying to hit me where it hurts. They're trying to get all the money out of me that they can. They're trying to make me look as bad as possible, no matter what we're doing. And it's really unfortunate that the court system even allows this situation to go as far as it has. Because as I've said from the get-go with this entire situation, this case is a massive waste of the court's time. There is no lawsuit here. There is nothing. I've never done anything wrong. I've never done anything illegal. They're trying to prove that I've done things that I haven't done. And apparently in the United States of America, if you don't like someone enough, you can just sue them for whatever you want. And then they have to explain that they're innocent. And that can last months, if not in this case, years. We're going on a year and a half at this point, and we're still trying to figure out jurisdiction. The court case has not even been officially accepted and heard yet. Just imagine, by the way, if it does get heard, that means that's when the case actually starts. It hasn't even started yet. And here's the other thing, and I'll leave it at this. If they decline to give you jurisdiction in New York based off of what they've given, the concern that I have with it is they could say there's no jurisdiction here. You need to file it where he lives. Then they come to California and try to sue me over here. That is scary because I've already sunk a lot of money into this. Thanks to the community supporting me, it has taken a massive weight off my shoulders and a huge stress off my family. I could only imagine if I didn't have the support of the community, my life would be in complete shambles right now. Thanks to you guys, it's not. And I'd like to think what she's doing to me, I think her whole intention was to make me have my life in shambles. Ironically, the harder she pushes this lawsuit, the better I keep looking, the better my channel does. the better that my perspective in the community is, because people can see what's happening. Logical people. Sure, you'll get the lunatics out there that will read stuff, or the cucks, the people that will just slay queen. Whatever you do, you're right when it comes to this kind of stuff, regardless of what the facts actually are. At the end of the day, there's nothing that I've done, like literally nothing. So even if this does get accepted in New York, I almost argue that would be like a comical court case. Like what are they going? I could only imagine how her lawyers have handled me already and painting me in the worst light possible with everything that I say, how disingenuous it is. I could only imagine the way that they would approach me in the court case. It's scary how people talk about people. It's scary. Simps. Yes, thank you. Simps. The simps out there. My goodness. There's a lot of simps, and it's kind of comical because these simps, I'm like, do you not actually, can you not step outside yourself and look at the situation for what it is? How ludicrous this lawsuit actually is. Like, it comes down to, maybe they're simps for her. Maybe they just hate me too and want me to be taken down because they just hate me. And there's people just rallying behind her because they don't like me. That could be a thing too. But whatever it is, it's not going good for her right now. And this was a massive blow to their case. Does it mean that for sure that jurisdiction won't be held? No, it doesn't. It doesn't mean anything like that. But this right here, especially if you read the just 2 days after the delay, this, I read into this that the judge is annoyed with them. That's how I read it. And maybe I'm looking too far into it, but that's how I see it. And I would argue that this is hopefully, fingers crossed, hopefully the judge is looking at this like, shit, or get off the pot. Do you have anything or not? Because at this point, this is turning into a massive waste of time for the court system. I'm hopeful that's the way they feel about it. And I'd like to think at this point, all the information has been given to them. So the next step in the process is to figure out if there is jurisdiction or not. And then from that point, this could theoretically finally be over. Hopefully. We'll see. I'll keep you guys posted, but for now, I'll leave that there. Kevin Osiris says, the request for sanctions tipped their hand that this is only a nuisance lawsuit. Well, I would argue they've tipped their hand like 20 times already with that. And the court is still going through the motions with everything. And maybe, again, like I said before, hopefully they're going through the motions because they theoretically that's how they have to approach these, so that they can't counter it and be like, oh, the judge was being ignorant to our reality and now we need to refile again or something like it's. They're going through all the steps to hopefully cross their T's and dot their I's with it.